Welcome back to Morning in America. It's about 12 minutes to the top of the hour. Hope you're on time. That confidential draft opinion of the Supreme Court leaked overnight. It's huge news. Everybody's talking about it, revealing that preliminary decision that could possibly overturn abortion rights. We are joined in studio by Paul Lisnek, a political analyst and a friend in our NewsNation Next Star family. We want to discuss some of these political implications. Obviously, you've interviewed a lot of people, presidents, governors, members of Congress. I'm wondering if any of your friends in Washington are talking yet about how big a deal this is. They will be talking about it all day today. And in fact, it's already been reported that President Biden, who's going somewhere today, will be talking about it before he boards the plane. So this is huge news. You know, there have been leaks in the past, like of a decision the court's going to make. In fact, the original Roe decision back in '73, the decision itself got leaked. But what's never happened to anybody's knowledge in history is the leaking of an opinion, of the actual 90-plus page written opinion that apparently was written by Sam Alito. And Sam Alito saying that this is not constitutional, that really abortion rights, the decision from Roe v. Wade was erroneous from the start. But this is more than just about that huge landmark case. I mean, there's a mention of Casey versus Planned Parenthood and also Mississippi's recent decision to ban abortions at 15 weeks, right? Yeah, so what most people expected the court to do was to simply acknowledge as constitutional the Mississippi case, which would have taken it to 15 weeks, because that's an incremental step. Right. And Chief Justice John Roberts, and this is his court, this is the Roberts court, that would have been a step he would have taken. But his name's not on the majority opinion. So what most likely happened here is that Roberts could not sway enough of the justices to basically say, let's just go with the Mississippi case. And so 5 of the most conservative justices, including 3 of President Trump's appointees, are all basically saying, no, abortion, not a constitutional right. But Adrienne, I have to add, here's what's interesting. It is true that it's not in the Constitution, but it goes back to actually 1965. That's the first time that the Supreme Court recognized what's called a right of privacy. Lots of things since that point are not in the Constitution. And so the question is, if you acknowledge that if it's not in the Constitution, it's not a right, then this could be, under this court, just the beginning of a variety of things that this court could take up over the years to come and say it's not in the Constitution, therefore it's not protected. So this is bigger than abortion. This could actually, I mean, for a lot of constitutionalists, people who want this pure, literal translation of the Constitution, this could be a huge win, but it also could set precedents for a lot of other cases. Well, this gay marriage, which was passed in 2015, is something, that same-sex marriage, that could be on the books saying, well, that's not in the Constitution, and so there's no right to that. So yeah, is it a slippery slope? Yeah, I don't mean to frighten anybody with that, but it can be if the court stays with this kind of philosophy. And so yes, and the variety of things that are not specifically in the Constitution, because that's what the strict constructionists basically say. If it's not in the Constitution, it's not a right. Mm-hmm. In terms of maybe the other side of the coin, could there be some who argue that, listen, this is the compromise. The Supreme Court rules that abortion is illegal at the federal level, but the states have the right to decide. So if you want to get an abortion, you might have to travel across certain lines to actually get the procedure done. Well, what's happens here is, if this is the decision, we don't know that, it's not been confirmed, it's a Politico report, but if it's a decision, then once it's announced, 13 states around the country actually have what are called trigger laws, which mean in 13 states, abortion immediately illegal. Mm-hmm. There are a variety of other states, it takes it to about half the country, a little more than half the country, that had laws that were on the books that got deemed unconstitutional when Roe versus Wade came out. Those now come back. And then you have just under half the states in the country that basically, like Illinois, for example, where abortion would remain legal. But you have to remember that this step, you know, Planned Parenthood versus Casey, which you're right to say also gets overruled in this reported decision. What Planned Parenthood said was, look, abortion is a right, but we have a right to limit it. And so it has to place what would not be considered an undue burden on the woman. That's been the test since 1992. Mm-hmm. This throws that out as well. So it completely eliminates the right. There are so many people excited about this, impassioned about this, saddened by this. There is so much emotion on this story, and it will always be that way. Thank you so much for being in studio. Sure. Thank you so much for watching. Make sure to click on the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.